to Crime in Court. My name is Heather, and this is another episode in my tragic death of Sandra Birchmore deep dive that I'm doing. And we're almost at the tail end of this, so we have this episode and then one more to go with the hearings regarding the two officers, the Stoughton officers who are still pending certification determinations because they have post commission hearings. So we're going to go over their recent hearings and then that'll bring us up to date. So, with this episode, we're going to be watching the July 12th hearing where this is basically William Farwell is one of the officers who is the defendant, one of the defendants, and he is trying to get the judge to compel the AG to turn over their discovery. And we read through in the last episode all of the AG's reasons why it's because there's an ongoing investigation and disseminating this information would be detrimental to our, effective law enforcement. So, my dog barking. So that was pretty much, excuse me, that was where we left off last time. So we're going to pick up right there. We read through the whole civil complaint, most of it. I mean, we skipped through a lot of it because whatever, but I gave you the link to that in the last episode. If you want to go back and look at the criminal complaint and read through everyone's answers and where we got to this point today. But we pretty much went through everything. We just didn't read through everyone's replies, but we got through a lot of it, at least on a surface level. So that brings us to today, or to this. Today is as in July 12th, 2024. This is the latest hearing with everyone is has representation on the line except for Stoughton PD, I believe, because and you're going to hear right in the beginning they're talking about someone not being able to attend this in Zoom meeting. So I think that's who they're talking about is whoever the representative is for Stoughton PD. And just full disclosure, this is the young. Oh wait, I just turned. Forgot I had my other camera on. Full disclosure, this is the Young Jerks stream because Mike Crawford, who you can actually see his name on the screen right there, he is really good at streaming these. I wanted to make sure that we went over it too. He just streams it with no commentary, but I wanted to go over it and give you guys commentary. So you might see some pop-ups now and then of people commenting on his stream. But other than that, that's all you need to know. So let's go. This is the estate of Sandra Birchmore. So representing Sandra Birchmore is her aunt, Darlene Smith. Darlene is represented by an attorney that's on this call. So none of the actual parties are on this call, or at least they don't speak, but only the attorneys for these parties are going to be on this call and the judge. So away we go. And please hit that like button as we dive in. It helps the algorithm.
I believe he originally indicated that he would not be with us, at least as far as yesterday. I'm not sure that counts for today as well.
I'm also not sure we told him about it for today, so I'm realizing.
He wasn't going to attend, Your Honor, I think.
Okay, so he conveyed to all counsel that he wasn't planning on attending the oral argument yesterday?
Yep.
Yeah, sure.
Okay, then he can go ahead and proceed then.
Thank you, Your Honor. For the record, call in 2282 CV01197, the case of Darlene Smith as the personal representative of the estate of Sandra Birchmore versus Matthew Farwell et al. If counsel be so kind as to introduce themselves for the record, starting with the plaintiff's attorney.
Good morning, Your Honor. Stephen Marullo on behalf of Darlene Smith as personal representative of the estate of Sandra Birchmore.
Good morning.
Good morning.
Good morning, Your Honor.
Your Honor, Robert Still on behalf of Robert Devine.
Good morning.
Good morning, Your Honor. This is David Bay on behalf of William Farwell. I'm the moving party.
Good morning.
That means William Farwell, the moving party, he's the one that made this motion to get the AG's office to compel the discovery.
Good morning, Your Honor. Good morning, Your Honor. Amy Bratsker for the town of Stoughton.
Good morning.
Morning, Your Honor. Attorney Brian Welsh for defendant Matthew Farwell.
Good morning, Your Honor. Lisa Mackey on behalf of the Attorney General's office.
Good morning. All right, so we have everybody now. Thank you again to everyone's flexibility so we could get this rescheduled promptly. I have had an opportunity to read the briefs. I have read several of the cases cited. I hope that will allow you to streamline some of your oral arguments, but why don't I go ahead and let first Mr. Bay argue, and then I'm going to hear from Ms. Mackey and anyone else who would like to argue. I will allow them time. Mr. Bay?
Thank you, Your Honor. And thank you for reviewing the briefs, Your Honor. This is a case concerning the death of a Sandra Birchmore, Your Honor. And my client has been, there have been claims against my client, William Farwell, related to that death, Your Honor. What we're looking to do is obtain records from the Attorney General's office concerning any investigations, anything related to that death or investigations related to my client or any of the defendants in this case, as I believe that it's significantly relevant to the facts of this case, and to ensure that everyone is aware of all the facts and investigations concerning this case and the death of Ms. Birchmore, as well as the investigation into the defendants. Now, Your Honor, as far as the privileges, the basis for the Attorney General's office for objecting to our motion to compel, I'll address them. As far as the law enforcement privilege, Your Honor, although there has been allegations that there is an ongoing investigation, I understand that that there may be, Your Honor, but we're in a situation here where we're on trial. We're on track for trial, Your Honor. My client has one opportunity to prove his innocence here, Your Honor, and the Attorney General's office could go on for years. A murder charge, which is, I would imagine, something they'd be looking into, of course, has no statute of limitations, Your Honor. And that being said, Your Honor, we have an exigent need for these records at this time, so we can evaluate it and analyze what, if any, other defenses my client has to liability, which may be contained in the Attorney General's office records. Therefore, I would suggest that as far as the balancing goes, Your Honor, our need for these records outweigh any law enforcement privilege benefit to the Attorney General's office. That being said, Your Honor, the town of Stoughton has produced extensive records in this case, over a terabyte of information, Your Honor, and we've been able to do that safely by way of an agreed upon protective order, which all counsel agreed upon and all counsel thus far has abided by. And therefore, Your Honor, I do not see any harm to the Attorney General's office if we're able to all agree, and I would expect that all counsel, which have been reasonable to date, would agree to that protective order. And so therefore, Your Honor, I don't see the harm to the Attorney General's office or the general public for producing these records, Your Honor. Also, Your Honor, as far as the attorney-client privilege, Your Honor, I'm still unclear as to who the client is that the Attorney General is referencing. There is and I see no prejudice to anyone as far as any alleged client in this case for the production of these records. And again, Your Honor, there is again the weighing of the benefits and the weighing of the detriment to my client to not producing these records, and the detriment to the Attorney General's office, Your Honor. I would say certainly weighs in our favor for the production, and not just my favor, Your Honor, but the favor of all of the parties in this case, which is why this motion was essentially non-objected to and even assented to by the plaintiffs here, Your Honor. This is information that we all need, not just my client. Last, Your Honor, I would suggest that the work product privilege is not applicable here, Your Honor. The records we're requesting are not work product. It does not appear from the affidavit of Attorney General Michelle Granda. The information that she's represented that she is in possession of does not appear to be work product. It appears to be simply the investigation, the state police's investigation into this matter. Now, I will say, Your Honor, looking at Michelle Granda's affidavit attached as, I believe, Exhibit 1 to the Attorney General's opposition, Your Honor, there are a number of, and this will probably clear some things up, there are a number of items in that paragraph number 6 that the Attorney General's office has identified that we do in fact have and that we do in fact do not need. We have received, Canton Police Department has responded to our Keeper of Records request. They have produced the information in their possession.
So I'm sorry, I don't mean to interrupt you, but I want to make sure that I'm getting this because I have the categories of documents laid out as well. Have you received both the incident report and all the supplemental narratives?
From the Canton Police Department?
Yes.
Yes, Your Honor. Yeah,
all right, so, okay, go ahead.
Also, Your Honor, as I said, the Stoughton Police Department, they have responded, as well as the town of Stoughton. So we do not need that to be reproduced again. What we don't have, Your Honor, is these state police records, which, I was surprised to see that was in here, number 6, because we have issued a Keeper of Records request to the state police in this case. And I received a response. I'm looking at it right now on my computer, and they informed my office on July 11th. Looks like, oh no, I'm sorry. July 11th of 2023, last year, a day ago, that the state police does not have any records in their possession in response to a keep of records request. So I was certainly surprised when I saw paragraph 6, and it seems to note an abundance of records generated by the state police as well as the state police that are assigned to the Norfolk District Attorney's Office.
How often does that happen? Where the state says, no, no, we don't have anything. And it turns out they actually do. I bet that happens a lot.
Was unaware of, and I presume that the state police did not have anything based on their representations to my office in response to our keep of records request. So that really is it's from what I can tell from Attorney Granda's affidavit, that appears to be the only thing that we don't have on her list of items that she represented the Attorney General's office has. And what she has listed here is really, it appears to be just investigative materials that the state police have generated. I'm looking at records related to the welfare check, to the unattended death. And they say that the affidavit states that these records consist of observations and investigative activity of the state police and witness statements obtained during their investigation and forensic evidence. This information, like I said, Your Honor, is relevant and important for not just me, but all of the attorneys on this Zoom to review. Now, Your Honor, I would suggest that we even have a more compelling need for this in light of the most recent disclosure of the plaintiff's expert, Dr. Michael Bodden, who was opined that Sandra Birchmore died at the hands of the defendant, Matthew Farwell. That is significant, extremely significant, especially in the context of the fact that it appears that there's been some extensive investigation by the state police on maybe this issue. I'm not sure, but I would imagine that there was some investigation on this based on what I can see from Attorney Granda's affidavit. And that is certainly very compelling and important for, again, not just myself, but all the attorneys on this Zoom call to review. Because if that is the case, if there is in fact, an alleged murder here, that is certainly extremely exculpatory evidence.
So I've mentioned this on other streams. The original determination, originally, the medical examiner thought it was, or concluded it was, by her own hand, Sandra's own hand. However, the family of Sandra Birchmore hired the world-renowned, really expert, the forensic pathologist, Dr. Michael Bodden. And I just learned that he did autopsies on like Martin Luther King and somebody else, I can't remember, like way back then. Yeah, it was probably like one of his first, I guess. I have no idea. But so he is world renowned and has come forth and said, after reviewing all the autopsy evidence, he believes that this was not by Sandra's hands, but was a homicide. And if that is the case, that means that any one of these men could be suspects. We know Matthew Farwell was the last one seen in her apartment right before her communications, or just after her communications to a coworker had stopped. So she stopped talking to one of the coworkers, and at around, let's say, I don't want to give a number because I don't remember. So if she stopped talking to her coworkers maybe like 15-20 minutes before Matt Farwell comes over to her apartment, and then he stays about 28 minutes in her apartment and leaves, and she's never heard from again. So that is probably the number one suspect, especially since he had a wife that was about to give birth the very next day, and also Sandra was pregnant and claiming it was his. And one of the friends of hers had said that she was even trying to get money from him, or trying to go after him for money, saying that she wanted a certain amount of money for daycare and things like that. So that's a huge motive right there for Matt Farwell. So, and if it is a homicide, which, come on, we all know that it likely is, allegedly, then that does change the game for all of these people because, like I said, they're all potential suspects. However, they all have separate attorneys, which is good because let's say William Farwell's attorney, this guy, David Bay, says, uh, hey, from all the evidence, it looks like, and this is a speculation, I'm just using a speculative scenario. What if he says he looks at all the evidence and says, Your Honor, it really looks like Matt Farwell could be the suspect of this crime, not my client. He has no duty to protect Matt Farwell, but as the attorney for William Farwell, he has a duty to protect William, even if that means throwing Matthew Farwell under the bus, which he probably wants to save his client. So there's that. So there could be exculpatory evidence leading to Matthew Farwell in this investigation that the AG's office is doing. And there could be, could be inculpatory evidence towards Matthew Farwell. I said the wrong thing. There could be evidence that points directly to Matthew Farwell throughout this AG's investigation, potentially, and it might clear or exonerate the rest of the people on this of homicide charges. Not necessarily the other charges that Darlene Smith is coming at for the negligence, for the emotional distress, for all those things, for the conspiracy. All of those things are still on the table, but the homicide, if it ever turns into someone's going to get charged, which as of now, Norfolk District Attorney's Office has this case, and it's under Michael Morrissey. So as long as Michael Morrissey's in office, I don't think anybody's going to go to jail for Sandra Birchmore's homicide. However, if a new DA were to come along, or if the AG's office or the feds were to do something about the individuals in this case, meaning handing down indictments, then and only then would the DA's office probably be forced to go along with it for publicity's sake, even though they wouldn't want to charge their own officers. Well, these are Stoughton, sorry, not their own, but still, I mean, they're protecting their own. They're protecting, well, Stoughton, I guess, is still in Norfolk County, so that, never mind. But yeah, so they're protecting their town, their people, their law enforcement. Michael Morrissey is, by keeping this sham going on, by pretending like Sandra was not, uh, that she did not meet her demise by someone else's hands. Anyways, sorry, that was a long rant. I get passionate about this stuff. So basically, it changes the whole game if this goes from a self-deletion to a homicide.
For all of the defendants on this call, except for Matthew Farwell, of course. But I would imagine it's also important for Matthew Farwell to review, because if he's going to be accused of that, he needs to understand what investigation and what evidence would support something like that, which appears to be in the possession of the state police. That being said, Your Honor, that is the reason why we've subpoenaed the Attorney General's office, and the reason why we have made this effort to compel this information from them.
All right, thank you, Mr. Bay. Just playing devil's advocate for a minute, isn't the revelation or the disclosure from the plaintiff's expert, though, also make it more likely that there's a true need for an ongoing investigatory exemption to be applied?
Well, you raise a good point, Your Honor. That's fair. But it is the plaintiff's expert, Your Honor. So, I'm somewhat speculating whether or not the state police are investigating Matt Farwell as well. I just raised that issue because it's a live issue, Your Honor, and
He speculated that they are investigating Matthew Farwell. Interesting. William Farwell's attorney is speculating that.
Even if there is an ongoing investigation, Your Honor, there is the option of a protective order, Your Honor, that will protect the information from getting out past the attorneys on this call.
All right. Before I turn to Attorney Mackey, just a couple things I want to make sure that everybody's on the same page, because I think a lot of things have narrowed by virtue of the identification of the categories of documents that the Attorney General has. We've already identified a couple of them or sort of touched on this issue, but I want to sync that up with my notes and make sure all counsel are on the same page and nobody views it differently. The categories that I understand that the Attorney General has identified, I broke down into 4 groups. the Canton Police Department incident report with supplemental narratives, which I understand is really not something that the parties are seeking at this time because they've already been produced. Is everybody in agreement with that?
Yes.
Yes, Your
All right,
Honor.
I see.
Yes, Your
All right, great. The Stoughton Police Department Internal Affairs report, I think everybody is in agreement that that has already been produced, and so the Attorney General would have no need to produce that. Is that accurate?
Yes, Your Honor.
Yes, Your Honor.
All right, then after that, I have, I think what Mr. Bay was addressing, the Massachusetts State Police records, which would consist of the observations and investigative activity of the Massachusetts State Police as identified by the Attorney General's office, witness statements obtained by their investigators, and digital forensic evidence. Does that, everybody agree with that in terms of how the Attorney General's office has identified the documents?
Yes, Your Honor.
Okay. And then, so that's still a live issue, and I think the other live issue still is third-party records obtained by the MSP through search warrants. I think, is that still a live issue for everyone?
Yes, Your Honor.
Yes, Your Honor.
Yes.
Okay. All right. Let me turn to Attorney Mackey, and I would invite you to argue however you see fit in terms of the Attorney General's position in the matter, but I am particularly interested in when the last time it was that any investigatory steps were taken in this matter, and I'm hoping you can address that. Go ahead.
Thank you, Your Honor. And I apologize for yesterday not being in the at the hearing. I was unaware, and I appreciate the court's flexibility in rescheduling for today. There is an ongoing investigation. It continues to be very active. I would have to, again, consult with my colleague, Michelle Granda, to see the last time that something particularly active occurred, but the investigation is not over. It is not in a stalemate in which it will not continue. There are multiple law enforcement agencies involved in this ongoing investigation. And as you can understand, Your Honor, that each law enforcement agency is reluctant to step on the toes of the other. And to the extent that there is a homicide investigation taking place that, the Attorney General's office is not handling, it would not do anything to interfere with an ongoing homicide investigation. And so while it may not be, currently moving at a quick pace, it doesn't mean that it won't pick up in the very near future. With respect to the
Well,
state,
I'm less concerned about whether it's moving at a quick pace and whether it's actually moving at all. It's, as you know, the burden's on the agency. There's a presumption that the records are subject to disclosure. The burden's on the agency to prove with specificity that somehow these documents qualify for the exemption. And I've reviewed the affidavit. There are some details, but very few details, and it's not, in my mind, terribly specific about why the agency does not need to.
Yeah, we read through the filing from them, and there was basically the reasons were it's protected and not it's exempt from disclosure, and also this whole investigation ongoing thing where there's always this boilerplate answer. There's an ongoing investigation, and any form of giving away our information would hurt our chances at law enforcement, whatever, blah blah blah. So yeah, so that is the answer that we've gotten mostly.
Disclose or should not have to disclose these documents.
well, the investigation is ongoing. The AGO is in a particularly difficult spot here where it is trying not to reveal too much to the defendants in this case, to the extent that they would be the targets of the investigation. And so I recognize that
I just want to point out that's not the first time that they've said this. It was also in their motion that this would be God, I am so slow at thinking today. They said in their motion that this would also be a problem because of the fact that the officers are targets of the investigation. So being a target, you don't want to give away all the information that you have that you can use to arrest them. So that they're kind of walking a fine line here, I guess. And I guess it's up to the judge. It's going to be up to the judge to decide how to rule.
current steps or most recent steps were not identified in terms of what the AGO is doing, but it certainly intends to continue investigating the conduct of the defendants in terms of their criminal conduct. So if there's additional...
Are there any witness interviews scheduled or on the horizon?
On the horizon.
One of the things that the AGO, one of the things that was argued in the brief, related to how future interviews may be colored if these things are disclosed.
Yes, Your Honor, the AGO does intend to interview witnesses, but like I said, because there's ongoing investigations by other agencies, there is an effort not to jeopardize that and to kind of wait until it's not going to jeopardize another investigation before interviewing those witnesses.
So the general topic of the investigation, so far as I could glean from the brief, related to the relationship between some Stoughton officers to Ms. Birchmore prior to her death. That's over 3 years ago now. Is there anything else you can tell us about the subject matter of the investigation?
That would be, Your Honor, it's the conduct of the defendants in the scope of their jobs as police officers and their relationship with the decedent. And so,
Let's play that again. This is important. This is what their investigation is about.
the conduct of the defendants in the scope of their jobs as police officers and their relationship with.
So their conduct as a police officer and their relationship to Ms. Birchmore. Period. Full stop. End of story. They are looking at the inappropriate relationships that were going on, the inappropriate things that were happening on the job and to a minor. So that's what I think is happening. That's what they're looking at.
The decedent. And so,
but all of the information on that category, I would guess, has an end date with Ms. Birchmore's death, unfortunately, correct?
yes, Your Honor.
So I'm trying to understand any potential new revelations that could prompt some ongoing activity at this point, if that's the scope of the investigation.
Well, for example, there's a question of whether there was, inappropriate sexual conduct that occurred here, and in terms of the dates and the activities and et cetera. So that's another element of this investigation, as well as, the public corruption question as to the defendants during that time.
All right. Obviously, the question of would the release probably so prejudice the possibility of effective law enforcement that such disclosure would not be in the public interest. Obviously, there's a significant public interest at stake when there's allegations of police officers engaging in these practices. And so the public interest in disclosure of the documents is significant. I understand that the public interest for any law enforcement investigation to be able to be pursued without being undermined is also significant. And I understand that the targets of the investigation are the people that are seeking disclosure, and that makes this case somewhat different from most of the cases that the parties rely upon. But in some respects, it doesn't really matter because of the case law, the standard is the same.
Yes, Your
everybody's in
Honor.
agreement with that, correct?
Yes, Your Honor. And if I can just point out the distinction between the public interest and investigations of police misconduct, this is an ongoing criminal investigation, not internal affairs investigation. I think the case cited by that was cited in the most recent issue where this came up involving, and the name of the case is escaping me, I'll bring it up in a second, was a shooting involving police officers, and they had been clear. There had been some sort of resolution from the district attorney's office at that point. And so the ongoing nature of the criminal investigation was over. The ongoing internal affairs investigation was continuing. And so there the court decided that it was in the public interest to release the information because it was an internal affairs investigation. And in that circumstance, the public interest with respect to the misconduct of police officers trumps their need for privacy. And the whole, witnesses being candid and coming forward didn't apply where all of the witnesses that are being interviewed are fellow police officers or police officers that were at the scene of a shooting. Here, it is different. It is the state police observations with respect to an unattended death, and all of the statements and forensic evidence given to the state police regarding an unattended death is still ongoing in terms of the criminal portion of the investigation. I'm not privy to the subpoena that was served on the state police last year, so I can't speak to.
Going, and I have to hear this.
I can't speak to what the response was there, but
yeah, I don't know what the heck that was.
We're unaware of the state police records being turned over or that unattended death investigation has concluded. So it would not be in the public interest to disclose to the defendants in this case all of the witness statements made in an ongoing criminal investigation, both into their sexual relationship with the decedent, as well as the question as to whether or not this is a homicide investigation, and then the other instances of criminal element that occurred in terms of their conduct as police officers.
All right. I understand, particularly with the disclosure of the expert report, some of the concerns about whether or not there'd be an ongoing homicide investigation. I have difficulty understanding how investigation into incidents that extend to longer than 3.5 years ago are ongoing at this point and continue to be investigated. That I'm struggling with, Ms. Mackey. And while I understand your point about the criminal investigation versus the internal affairs investigation, it still doesn't get around the fact that the public interest in any allegations of this kind of conduct on behalf of police officers is high. So in looking at whether or not the agency has met its burden, that's one of the things I'm considering. Okay, well, let me just sort of.
You can kind of tell from the way she's talking that she might be leaning towards compelling the AG's office to turn it over. She's kind of torn about it, but she might be a little bit leaning towards granting this motion.
Cut to the heart of some of these issues. Certainly in the criminal aspect, I think this is much less common on the civil side of litigation. It is not uncommon to have limited disclosures involving protective orders where lawyers are not allowed to even share information with their clients. Why would that not be an appropriate way to move forward in this case?
Again, it's a protective order that limits the actual clients in this case from getting the documents, I think would still be prejudicial, as it is ongoing. And now people other than law enforcement know what all the witnesses said as law enforcement investigation continues. And with respect to the timeline of 3.5 years, Your Honor, the AG's office did not respond to the wellness check, did not conduct the unattended death investigation. And so the timing in which, the AG's involvement began was much, much later. And so, it's not that the AG's office has been sitting on this investigation for 3 years. It's that it came to the AG's office later as potential criminal conduct that needed to be investigated.
Well, do you know what the timeline on that is? Because I'm still, I wish we had the answer to the question of when some actual investigative activity has actually occurred, but we don't have that answer. Do you know when investigative activity actually began?
I mean, when the case was referred to the AG's office, I would say is when it began from the district attorney's office.
When was that?
I'd have to go back into my notes and look, Your Honor. I'm happy to supplement our motion or our position.
All right. What I'd like to hear from other counsel in the case, Mr. Marullo, it's my understanding that the plaintiff has assented to Mr. Bay's motion, correct?
That is correct, Your Honor. As Your Honor pointed out, my client and her baby have been deceased now for over 3.5 years, and an answer that it's under investigation after 3.5 years is not sufficient. The cases that are cited by the Attorney General's office actually weigh in the favor of the movement and the assenting parties, because they say that there is a procedure to be followed when documents are sought. The procedure is that the parties try to work out what documents can be presented, and then the resisting party, let's call it, provides a list to the court of what documents are not being presented, and then the court has the discretion of deciding what's appropriate, what's not appropriate. At this point, we don't even know what the Attorney General's office is investigating. We don't know whether it's investigating corruption within the Stoughton police, corruption within the
She's told us it's the corruption, the misconduct of the Stoughton police officers and their behavior with Sandra Birchmore. I guarantee they're looking at this whole grooming and CA aspect of it. And if there were others involved, other officers that were in this program doing these same things to the children in that program. So it is, I'm sure they want to investigate and make sure that they have the culprits that they know of, even though they're still walking free.
and police, whether the district attorney did an appropriate job at investigating this matter. At this point, my clients want some answers, and to be thrown a curveball that, well, it's an ongoing investigation, simply doesn't cut it. And we are aware that there's actually a superseding investigation by the Federal Bureau of Investigation and the U.S.
What? So now, not only is the AG's office still currently investigating the homicide of Sandra Birchmore, the FBI now, we know, confirmed by Darlene Smith, the attorney, or Darlene Smith's attorney, the Darlene Smith representing Sandra Birchmore, just told us that the FBI is investigating as well. So this is where I think the FBI came in for the Sandra Birchmore case and started investigating, and in that found a whole crap load of corrupt misconduct going on, including the Karen Reed case. And that's how I think the feds already knew about Karen Reed long before anybody else. All right. Well, that's my opinion. Okay. Continuing on. Feds. The feds now are coming into the combo.
U.S. Attorney's Office. We don't know exactly what that is, but maybe it's the same thing. Maybe it's not. It should not be an obstacle for my client and the decedents to be able to move forward with this matter simply because they keep saying it's a matter under investigation. The Reinstein case is clear, the Rayfuse case is clear, the Bugas case is clear, the Boston Globe case is clear that active investigations is not a carte blanche to keeping all records from the parties in a civil action or in any action. So regardless of whether the defendants may or may not be targets, we don't even know that at this point because that's unclear. But there has to be some movement because the civil case has to be moved along.
So it sounds to me, Mr. Murillo, beyond dissenting, you're actually joining in the motion.
Absolutely joining in the motion, Your Honor. All we want is the truth. We don't care what the truth shows.
He wants, Sandra Birchmore's attorney also wants the AG to come forward and disclose this information to all parties involved so that they are aware of what the AG's office knows in regards to this investigation, if they have a suspect, if that's what they're even looking at. It's kind of hard to try a case when you don't have all the evidence.
We want the truth.
All right. Does anybody else wish to be heard? I will turn to the topic of the attorney-client privilege in a minute, but I was focusing primarily on the investigatory exemption at this point. Does anybody else want to be heard on that? Okay. With respect to the claimed attorney-client privilege, it seems to me, Mr. Bay, and I'll put this question out to Mr. Murillo as well, since you've joined in the motion. It seems to me that to the extent any documents exist involving, memoranda, for example, strictly summarizing conversations or the thought processes of counsel involved, I don't think those would be relevant to the civil case or material to the civil case. And I'm not certain whether or not they would qualify as public records. I think I'd have to conduct an evidentiary hearing in that regard. And if they do qualify as public records, then there's the next question of whether or not they qualify for an exemption or a privilege in some respect. And the reason I throw those thoughts out there is because I'm not sure if we can narrow this a little bit further in terms of what's in dispute. Because even if we have a prosecutor or somebody else making all sorts of statements about their thoughts, I don't see a way that you folks could use that in the civil case. And I don't think that needs to be at issue in this motion, but I'm putting it out there to see if we could get to some consensus about that, or if that is an issue that we need to spend a lot of time on.
Thank you, Your Honor. I would tend to agree with Your Honor that the analysis of the information by the Attorney General's office is not something that I think would be overly helpful in this case. I still do struggle with who is the client in this attorney-client relationship. I think would probably better categorize as work product. But we are interested in facts, investigatory facts. We're not interested in an attorney's thoughts about those facts. So as far as narrowing the scope, I don't think that's a problem if you're going to be excluding the Attorney General's thoughts regarding the facts that has been provided.
Okay. Mr. Murillo, does anybody else wish to weigh in on that?
Oh, Your Honor, the question you raised goes to the very core of what I'm saying, which is, frankly, we don't know what we don't know. And in terms of categories of items and documents and so on, we can focus on that one item. But frankly, there might be many more items out there that don't clearly fit in any category. And I think it's the Reinstein case, which points out.
Well, right at the moment, I'm just focusing on this one item because I'm trying to narrow what the issues really are.
We're not interested in the Attorney General's analysis or thoughts on
Okay.
what's going on.
All right. I think to a large extent that would address some of the issues the Attorney General has raised under the category of attorney-client privilege. Do I have that right, Attorney Mackey?
Yes, Your Honor. And to the extent that the AGO's office has identified the categories of documents that it has not identified, memos or witness interview notes or anything of the nature. It is records that were created and are maintained by separate law enforcement agencies. And so there wouldn't be anything relevant within the Attorney General's office's communication between and amongst assistant attorney generals regarding these facts. It would all be, regarding this case, it would all be just communications with an analysis and the thoughts of the AAGs.
Have you personally been through the records that would qualify as the Massachusetts State Police records as you've categorized them and the third-party records obtained through search warrants?
I have not, Your Honor.
So you can't represent to me how voluminous those records are?
It's not that voluminous, and I think one of the concerns we also have is that we do not have the entire state police investigation. So we may have portions of it, but not all of it. So I don't know the number of pages, but we have the interview notes and the interviews and the observations of the state police with respect to the unattended death investigation, but we don't know if we have everything.
Well, the comments that are, or the arguments that is put forth by Mr. Murillo and Mr. Bay regarding the agency's response in terms of, just continually saying it's an ongoing investigation, I tend to agree with them that really it's hard for me to understand how this is an ongoing investigation. I know that's not all the only question here, but in this particular case, that seems to be the primary issue as to whether or not the exemption applies or does not apply. I know in some of the cases that you folks have cited to, we've seen voir dire of detectives. We've seen in-camera or potential for in-camera review. We've seen a whole host of things that has been done by the agency, or evidence has been put forth by the resisting agency to establish that the investigation is truly an ongoing investigation and that the disclosure could hinder the investigation or would not be in the public's interest. I don't think the agency has quite established that with the affidavits that have been set forth and the arguments that have been set forth. However, I am concerned, and just as the lawyers representing the parties in this matter have expressed concerns that we don't know what we don't know, I also have a concern about some of the issues raised by the AG's office, particularly in light of some of the recent reports regarding the cause of Ms. Birchmore's death. I do not want any investigations to be compromised by a wholesale disclosure of these records. I mean, one option is potentially an in-camera review, but I'm interested to hear from the parties of their thoughts on that.
Your Honor, if I may answer, that's one of the problems that the AGO has, is it has to find the line between identifying the category and stating why it's not in the public interest to disclose while still maintaining the integrity of the investigation and not saying next week, these are the 3 witnesses that are going to be interviewed by the AGO's office, by the AGO, and or, the grand jury is going to convene, tomorrow. Well,
there's some room between those two extremes though, right? I mean, I wasn't asking who you had asked who you had interviewed last. I just wanted to know when, and I don't have that answer, or whether or not there are even any other future witnesses scheduled or on the horizon, and I don't have that answer. All I have is that they intend to interview some more people, which is pretty vague, non-specific response, and a general intention is not the same as truly an ongoing investigation. So I'm trying to get at the heart of that without, recognizing that it's the agency's responsibility to come forward with some specificity to demonstrate that the records meet the exemption. And I don't really think that's clear to me at all. But I know there is some support in the case law to say that on a close call, one of the things I can do is order an in-camera review.
And the AGO would accept that and be able to provide the court with more specific information as to the activity that took place in terms of the investigation, why it has stalled for a period of time, not to be expected to be very long, but to make sure that the AGO does not undermine the integrity of other law enforcement investigations into this matter. And so if the court thinks that's appropriate, we could certainly participate in an in-camera review to
So basically, an in-camera review is in the court chambers on record, but not open to the public. And but it is recorded, I believe, and they're able to, go over and review things and be a little more discreet without, a big open courtroom that's public to everybody or open to the public. So, yeah, so that's what they are talking about, coming in and doing an in-camera review and potentially turning over redacted discovery for regarding this investigation, which makes sense to redact some things if they need to. But one of the arguments that the AGO made, the Attorney General's office made, was that it was an inconvenience to do this. So that was another argument that they made, just that they're inconveniencing me to do some work and I don't want to do it.
Further discuss the specifics.
And I think it would be helpful to me to get, as I think you're just suggesting, from the AG, not just the bare documents, but also an explanation as to why they feel the documents, and perhaps this will have to be broken down by each document or at least each category, could meet or does meet the exemption, I should say. Let me hear from the council about that thought as a way to move forward. Mr. Bay, Mr. Marul, let me start with you folks.
Your Honor, I think that's a reasonable way to resolve this close call. Certainly, I have no objection to that in-camera review.
Mr. Marul?
I agree, Your Honor. I'd like to see it done with not just broad categories, but a list of documents. We're informed that there aren't that many documents. They're not that voluminous, so it wouldn't be that hard to make a list, even if it's redacted, so it doesn't actually identify.
Oh, what I'm contemplating is actually getting the documents, not just a category. What I'm suggesting is that it would be my preference, and I don't think any of the counsel for the parties would object to this. It would be my preference to assist the court for the Attorney General's office to provide with the documents an explanation as to how they feel each document or why each document meets the exemption and should not be disclosed, because obviously looking at it in a vacuum may be more difficult from getting some explanation of the broader picture of what's going on for me, to assist me.
I absolutely agree with that procedure, Your Honor. Thank you.
So there you have it. The AG's office is going to have to go to an in-camera review and go through all of their discovery. And if there is discovery that they don't want to turn over, they have to have a good reason and in writing. So they have to provide a brief written to let the other attorneys know this is protected because, and the judge then can make the ultimate decision after reviewing it and deciding whether it should come in or not. So that is pretty much what the procedure is going to be.
All right, Attorney Welsh, Attorney Lowe, Attorney Braskier, does anybody have any other thoughts?
No,
Nothing
Judge,
from me.
I don't. I would agree with it as well.
Okay. Ms. Mackey, would you be able to do that within the next 30 days?
Yes, Your Honor.
All right. And I think from there, we determine how we proceed and whether or not things need to be under seal and pounded in terms of the motion practice that may result thereafter. Okay.
So she had 30 days from July 12th. So obviously this is August 20th as I'm recording this. So it's a little past their 30 days and they should have provided their brief. I will look to see if it is available to the public and if we can read it, because it wasn't on that docket or it wasn't on that big complaint file when we went through it because it hadn't been filed yet. So we will take a look at that if we have it in a future episode, but if not, we already did kind of read through her original brief as to why, but nothing was specific. So I don't know if this document is even going to be public because of the fact that it's in camera review and they don't want,
Okay.
they don't want certain things revealed to the public. So this is pretty much it. This is the end of their, let me just play it out to the ghost.
Yes, Your Honor.
All right. So what's the date, 30 days from now, that we should give the Attorney General's office a deadline?
That would be August 12th, which is a Monday.
So can you, if you could give me and again, we do not need the Stoughton Internal Affairs report. I don't want any documents that are not in dispute. We don't need any documents that are exclusively reflective of thought processes of any lawyers on the case. but we do need the MSP investigatory materials and the third-party records that were obtained through search warrants.
Okay, thank you, Your Honor.
Okay, all right. Anything else that we should address today?
No, Your Honor. Thank you.
No, Your Honor.
No, Judge.
All right, thank you all.
Thank you.
Judge.
All right, so there we have it. That is the end of their hearing. I don't know if there's any more hearings that are scheduled. You know what? Let me see if I can find the docket. Hold on. So I went to the docket. I don't see anything from the AG's office, but just for reference where we're at on the docket, let me make this a little bit bigger here. So 712 was the hearing that we just listened to, motion hearing to compel, scheduled on 7/12/2024 at 11:30 has been held. 30 days for the AG to produce the documents for in-camera review. And then the next thing on the docket is this defendant Robert Devine's motion for trial court rule 9 order. So he actually, Robert Devine, he filed the, was it this? Yeah, he had a new filing and what does he want? Access to records. Defendant requests decedent's entire court activity record to be produced. Oh, Robert Devine wants all of Sandra Birchmore's court records produced. That's interesting. So, it's a really short motion. I guess, you know what? Let's read it now. And it's been allowed. This is the court's writing. I can't read it all. I'll try. All right, so defendant Robert Devine's motion for a trial court rule 9 order. Now comes the defendant Robert Devine in the above matter and moves pursuant uniform rules on subpoenas to court officials rule 3. Subpoena duces tecum for records of the office of the Commissioner of Probation that this court issue a Superior Court Rule 9 order granting the plaintiff Robert Devine herein after Devine access to records of the office of the Commissioner of Probation for the decedent Sandra Marie Birchmore. Defendant requests decedent's entire court activity record be produced. As a reason, therefore, in the second amended complaint, plaintiff complains that Birchmore was abused mentally and physically by the defendant when in fact protective orders were sought by Ms. Birchmore against persons she believed had abused her or by persons who claim she aid them. So, okay, so there's some kind of something going on. But okay. Well, anyways, so he wants those records. The defendant had already found one restraining order that was either issued in 2018, which is within the time frame the plaintiff alleges Birchmore was being groomed, abused, or otherwise assaulted by Devine and the other defendants. It is believed that between the years 2016 and 2019, Birchmore made claims that she was aided by others and sought restraining/harassment orders against them. It is believed that additional restraining or harassment order requests were made in other courts. However, the defendant does not know what courts to search. It is understood that the Department of Probation has these records compiled as part of its database, which is not available to the general public. Information regarding restraining and harassment orders are not available within the Mass Courts database. Counsel for Devine has spoken with a keeper of records for the Department of Probation who will provide records if they exist once she is served with a court order issued under Trial Rule 9, which, what does it say? The defendant shall provide to the Office of the Commissioner of Probation sufficient personal identifiers for Sandra Marie Birchmore, name, address, date of birth, social security number, so that probation's central file, oh wait, I'm reading the wrong thing. Sorry, that is part of the motion. This is the footnote. Counsel for defendant Robert Devine received an email from and, and spoke with the keeper of records from the administrative coordinator to legal unit Massachusetts Probation Service. This email is not being produced as an exhibit since it contains a statement that distributing the email is strictly prohibited under applicable law. So this is really tiny writing. All right, so that's the footnote. Where did we leave off? Here. All right, so the only alternative available for Divine is to physically go to every court in the Commonwealth to review court records and see if a restraining order was requested by or against Ms. Birchmore. Checking with every court is unreasonable given that the identification of court activity is readily available through the probation department. So he just wants to cut corners because the probation department information is not available to the public. So they just want to cut corners. The defendant will use the records to identify persons who may have actually inflicted physical injuries and emotional distress on Ms. Birchmore as alleged in several of the counts within the complaint. I wonder if he's referring to the other individual that was grooming her and aiding her and all that. I wonder if they're referring to Matt Farwell because Robert Devine is trying to save himself here. So she might have been making, I don't know who she had complaints against. That would be interesting to know. And wouldn't that person also be potentially a suspect, whoever they are? The defendant will use the records to identify persons who may have actually inflicted physical and emotional distress on Ms. Birchmore as alleged in several of the counts within the complaint. Affidavits that usually accompany harassment and restraining orders may lead to evidence that will be admissible at trial. Pursuant uniform rules on subpoenas to Court Official Rule 3.3, the defendant requests that the court issue an order stating 1, that the defendant shall provide to the Office of the Commissioner of Probation sufficient personal identifiers for Sandra Birchmore so that probation central file personnel can narrow each request down to one record. And I don't know if that was a period or what. Okay, hopefully that was a period and not a comma at the end of that sentence. All right, number 2. That directs the official keeper of records for the Office of the Commissioner of Probation to provide the defendant's counsel, Robert Stowe, with attested copies of said records either through U.S. mail or email. So provided to the attorney for Robert Devine. That records shall include but shall not be limited to the identification of all restraining orders, harassment orders, or the like requested or issued against Ms. Birchmore. Records shall include but shall not be limited to the identification of all restraining orders, harassment orders, or the like requested by or issued on behalf of Ms. Birchmore. And that specifically limits the party's use of the attested copies of such records and the information contained therein to the purpose for which it was granted. So put a limitation on here that this information, if she does release this information, which she does, she allows this motion, then you can limit it. And that was certificate. Oh, so they provided some other documents with that, some affidavits or whatnot. But this was July 29th that Robert Devine's attorney did this. And then she allowed it with substantive opposition. The Office of the Commission, however, disclose information. I can't read that. Something to be confidential with pursuant to whatever rule or statute they're listing there, except for information pertaining only to Birchmore without future order of the court. Further, should the why did she do it this way? Should the parties receive any information that was subject to the order at impoundment, they may not disclose such information to any persons or entities without future order of the court. Wow, that was hard to read. It was so hard to read. Not only sideways, but really awful handwriting. So she did allow it, but she gave some limitations there. All right, back to our docket. That was the 29th that they did that, and then the court ruled, oh, they submitted some affidavits, and then 9A lists all documents filed. What was that? I think that was what we just read, because that was the court's response to that. Oh no, this is the list of documents that they filed with this. Okay. And then the endorsement. So 8.5 is an endorsement on motion for a trial court rule. This is where she allowed it, and this is where she writes it. Oh, without substantive opposition. There we go. So it was better to read it here. That was dumb. I read it. I read it the hard way. Oh well. And then, so as you can see, the Attorney General's opposition or brief is not in here. And then this just says on 8/15, general correspondence regarding confidential document received from Commissioner of Probation filed in the impoundment room. So this came from the Commissioner of Probation, meaning the information that they requested, that the Robert Devine requested regarding these harassment and protection orders, they received it, but it's under impoundment. So that's where we're at. We have not received the 30-day whatever. It's not on the docket, the response, the brief from the AG's office, but we'll see what happens. But we're all caught up now. In the next episodes, we're going to do the post-commission hearings for both Robert Devine and William Farwell, and then any future documentation or hearings that we have, we will continue to cover for you guys. So please hit that like button on your way out. Don't forget, and make sure that you are subscribed so that you don't miss any future episodes on the Sandra Birchmore case. And I will see you guys in the next one. Thank you so much. I really appreciate you guys. Thank you for watching. Take care. Bye now.